looked at the long-term care provisions. I don't know if you have, Brian.
I've spent very little. There is a little long-term care piece to the healthcare reform that's what you're probably referring to, and I haven't looked at it too much. From what I can tell, though, it's intended to provide. It's going to be for those employers that choose to provide it, and those employees who choose to do it. It's all going to be completely, voluntary. It will provide some significant long-term care benefits. If someone is on the long-term care coverage for like 5 years or so, then they are assured of having cost of like assisted living, covered by it. But it's not clear to me how that benefit is going to be provided. If it's only through an insured type product. I mean, it's referred to as a program. So I think if you're interested in long-term care, you're going to need to study that a little bit more than most people have already.
You may have seen last week that the COBRA premium subsidy was extended again through the end of May, and that there is some, that Congress may extend it through the end of the year. I would be surprised if they didn't, actually. So that is an FYI on the COBRA subsidy. You may or may not know there's an annual notice requirement, a new annual notice requirement under Medicaid and SCHIP, and we've included that as handout C. It pertains to special enrollment rights, permitting employees and dependents to enroll in employer health plan upon termination of eligibility for Medicare or SCHIP, and upon eligibility for premium assistance. So essentially it creates a new special enrollment, this law created new special enrollment provisions for these people, and there's a notice requirement that goes along with it. Mental health parity, the big thing there is previous to the law and regulations, a lot of health plans were getting away with the mental health parity, the prior mental health parity laws, which only restricted, we have 2 slides on this? Yes. Which only restricted that you could not have larger annual or lifetime dollar limits on mental health benefits than you did on medical and surgical benefits. And a lot of plans were simply revised to include higher copays with these and limit the number of inpatient and outpatient mental health visits. The new law seems to make that impossible to do. It sort of speaks vaguely to benefits and specifically to out-of-pocket limitations. And so I'll be curious to see what some of the insurance companies do with this and see what the language looks like. It becomes effective this year, I think after July. So this is and it also applies to substance abuse benefits needed because of substance abuse, whereas the previous law did not. So that is going to be a significant change in your health plans. Brian, you want to say a couple words about HIPAA?
Yeah, we're going to try to wrap up pretty quickly here with just a couple little things. Again, these slides now here have nothing to do with federal health care reform. These are just things that happened otherwise. But last year when the economic reform, economic assistance program bill was passed, the ARRA law, there had a provision in it that you may have heard about. In fact, we spoke on it last year a little bit, called the high-tech provisions, and it made some important changes to the HIPAA privacy and security rules. And the reason we talk about it right now a little bit is because there was like a 1-year delayed effective date, and that 1 year ran up then in February, just 2 months ago. The 2 main changes are that those privacy rules now, instead of speaking to covered entities, health plans and healthcare providers, and they had to contract with their business associates to make sure they help comply too. Now the law speaks directly to the business associates too. So anyone who contracts with a health plan or a health care provider and therefore has or generates protected health information now is subject to the same HIPAA privacy and security rules that the health care provider itself was subject to or the health care plan was subject to. So it's kind of like when you drop a rock in the pool. It's emanated now farther. These rules now apply to a larger group, namely all the business associates, than used to be the case. So previously they had to comply, but in an indirect contractual basis. Now they have to apply directly. The other main part of this expansion of the HIPAA and privacy rules in this part of this law was imposing some new civil and criminal penalties for violations and some notice requirements if there is a breach, even if it's a completely accidental or breach of the rules. And to use one quick little example here, a breach doesn't necessarily involve disclosing confidential protected health information to the outside world. A breach could simply mean someone in your own company getting access to confidential information, someone who wasn't authorized to do so. I mean, so if you're doing a good job of complying with the HIPAA privacy rules, you've got a limited number of people who have access to protected health information, and you keep that information under lock and key, so to speak. And even if it's in, you know, a file cabinet, maybe it's a locked file cabinet as opposed to the other file cabinets you have other information on, and only certain people have access to that. But now, let's say someone who was not among that small group of people snoops around, as many people might tend to do as a matter of human nature, and wants to find out information about a co-employee, comes across the PHI because it wasn't properly protected. That is a breach to have allowed someone to have access to that protected health information. And depending on the size of the employer and so forth, there may be a notice requirement to notify the person whose information was snooped into, for example, about the breach, and in some cases maybe even notifying the government. So some significant penalty and notice requirements imposed here that anyone, if you're involved at all in HIPAA privacy, you really need to be on top of, that are now applicable because that year has expired from when the law was passed.